In the Stan J. Caterbone. Petitioner. Your name. vs. United States of America. Respondent, S. On petition for a writ of certiorari to 11th Circuit Court of Appeals. Name of court that last ruled on merits of your case. Petition for writ of certiorari. Stan J. Caterbone. Your name. 1250 Fremont Street. Address. 17603. 1. Questions presented. Question number 1. Did the United States of America err in not granting a jurisprudential exception? C28 U.S.CSS 1291, 1292 in order to avoid having to consider the following, which would necessarily obligate another set of congressional hearings akin to the church hearings in 1973 whereby the CIA had to omit the existence of MKUltra, which it declared abandoned. Answer to question number 1. With regards to Esteban Santiago, mass shooter at the Fort Lauderdale Airport, for which this amicus brief was filed, and other mass shooters that have made similar claims of being victims of U.S.-sponsored mind control with a history of military training, are their constitutional rights to due process being compromised, and should the following not be granted? Victims of U.S.-sponsored mind control technologies operated by operatives, agencies, and/or in direct partnership with United States military, law enforcement and/or intelligence agencies or international collaborative are ensured their constitutional rights, are afforded the proper administration of law in accordance with their actions, and if such actions are deemed proxy to their handlers or controllers, and they are granted the proper immunitive defenses during criminal prosecutions by United States attorneys, state attorneys, and/or local magistrates. That any and all such diagnosis of mental illnesses are first deemed to be symptomatic of U.S.-sponsored mind control first, and treatments are to ensure that victims are prepared for a safe life and assured they are not a threat to society. That local law enforcement agencies and local police are to be advised of such circumstances and are prohibited from targeting and/or surveilling the victims in any way. That hearing voices and such related symptoms are not to be used for mental health warrants and/or hospitalizations alone, without a thorough analysis of the clay of suffering symptoms of U.S.-sponsored mind control. In the 1990s, then-President William Jefferson Clinton made public statements and apologies for military/intelligence programs using American citizens as non-consensual experimentees. Such public disclosures, at some point in time, should be addressed by the current administration of victims of U.S.-sponsored mind control. Question number TW. Is Pro Se petitioner Sta. Caterbone, his father Samuel P. Caterbone, Jr., and his brother Samuel A. Caterbone victims of U.S.-sponsored mind control technologies who suffered incidents and violations of civil, constitutional rights of non-consensual experimentation paramount to torture? L. Answer to question number 2, yes. Question number 3, did Pro Se petitioner Stan J. Caterbone fall victim to a criminal/civil conspiracy while engaging in whistleblowing activities in the ISC/CIA international arms dealer scandal in 1987, which continues to today, that now has manifested into a cover-up and obstruction of justice case of mass proportions? To answer to question number 3, yes. List of parties. X. All parties appear in the caption of the case on the cover page. All parties do not appear in the caption of the case on the cover page. A list of all parties to the proceeding in the court whose judgment is the subject of this petition is as follows. List of plaintiff appellants. 1. Stan J. Caterbone. List of respondents. 1. Noel J. Francisco, Counsel of Record. Solicitor General, United States Department of Justice. 950 Pennsylvania Avenue, NW, Washington, D.C. 20530-0001. Supreme CT Briefs at usdoj.gov. 202-514-2217. TE of Contents. Page No. Motion to exceed page length. Proof of service. 3. Questions of writ. List of parties. Opinions below. 2. Jurisdiction. 19. Constitutional and statutory provisions involved. Statement of the case. 20. Reasons for granting the writ. 29. Coxlution. 77. Index to appendices. Appendix A, opinions below. Appendix B, Caterbone family affidavits. Appendix C, 11th Circuit Case No. 18 to 10134, Reply Brief 2. Jurisdictional Order of January 29, 2018 Re F.T. Lauderdale Shooter Amicus Appeal, February 3, 2018. Application for Informa Pauperis. E of Authorities CD. Cases page No. 351 F.3 D 1348, 2003. Robert S. Wolfe, Edward Turner, Edward E. Waller, Gray Wolfe. Holdings, John G. Coughlin, Plaintiffs' Appellees. V. Cash for titles, DBA Charles Richard Homa, ETAL, Defendants. Philip S. Stenger, G. James Cleaver, Cayman Islands Liquidations Creditors Committee, Appellants. No. 01-16973. 11th Circuit Court of Appeals. Filed December 5, 2003. Statuities and Rules. 1. Amicus Case Law. A person with strong interest reviews on the subject matter of an action may petition the court for permission to file brief, ostensibly on behalf of a party but actually to suggest a rationale consistent with its own views. Black's Law Dictionary 75, 5th ed. 1979, News and Sun Sentinel Co. v. Cox, 700 F sub 30, 31, S.D.FLA 1988. Federal Rules of Civil Procedure lack of parallel provision for regulating amicus appearances at the district level. District courts have inherent authority to appoint or deny amici, which is derived from Rule 29 of the Federal Rules of Appellate Procedure. See Mobile CNTY. Water, Sewer and Fire Prot Auth Incorporated v. Mobile Area Water and Sewer SYS, Inc. 576 F sub 2 D 1342, 1344, SD ALA 2008. Inasmuch as an amicus is not a party and does not represent the parties but participates only for the benefit of the court, is solely within the discretion of court to determine the fact, extent, and manner of participation by the amicus. Cox, 700 F sub. At 31, citation omitted. The decision whether to allow non-party to participate as an amicus is solely within the broad discretion of the court. Resort Timeshare Resales Incorporated v. Stewart 764 F. Sub 1495, 1500, S.D.FIA.1991, Ellsworth Associates Incorporated v. United States 917 F. Sub 841, 846, D.D.C.1996. This case is a pending criminal trial. As such, it is noteworthy that there are specific constitutional protections that exist in criminal cases that do not otherwise apply to parties and civil actions. See United States v. Ward 448 U.S. 242 248, 1980. 2 Pro Se and Informa Pauperis. Commonwealth v. Hagenstaller, 699 A2D 767, Pa Superior, 1997, Pro Se appellant sought review of conviction for violation of county ordinance with rule of appellant procedure. Court conducted a thorough, independent review of the record, and found sufficient evidence to sustain the conviction. Hempfield Township v. Hapchuk 153 Pa Commonwealth. 173,620 A2D. 668, 1993, Pro Se brief failed to comply with PA rules of of appellate procedure, but the failure to comply did not substantially impede the court's ability to review the issues presented and therefore considered the merits of the case. PARFP Rule 552, 561 Indigent S 16.2 Informa Pauperis, Griffin v. Illinois, 351 U.S. 12, 76 SCT 585, 100 L. ed. 891, 1956, states indigent has right to free trial transcript for appeal of right. In Pedersen v. South Williamsport Area School District, the courts interpreted due process as essentially fundamental fairness is exactly what due process means. Furthermore, the United States District Courts in Perry v. Coiler, 1978, 524 F2D 644, have concluded the following: even the probability of unfairness can result in a defendant being deprived of his due process rights. The first issue to address is that of the plaintiff's right to due process, as prescribed by law. In Pedersen v. South Williamsport Area School District, the courts interpreted due process as essentially fundamental fairness is exactly what due process means. Furthermore, the United States District Courts in Perry v. Coiler, 1978, 524 F2D 644, have concluded the following: even the probability of unfairness can result in a defendant being deprived of his due process rights. 3. Civil rights. 51,983 Civil Rights Acts and 18 USCA Acts state the following: the underlying purpose of the scheme of protecting constitutional rights are to permit victims of constitutional violations to obtain redress, to provide for federal prosecution of serious constitutional violations when state criminal proceedings are ineffective for purpose of deterring violations, and to strike a balance between protection of individual rights from
state infringement and protection from state and local government from federal interference. 18 USCA SS 241, 242, USCA, Constant Art. 2, 53, amend. 13, 14, 5, 15, 52, 42 USCA 55 1981 to 1982, 1985, 1988, Federal Rules Civil PROC Rule 28, USCA. In Ascolace v. Southeastern Turnpike Authority, C 925 FSUPP 351, the case supports the notion that one of the principal purposes of S 1983 was to give remedy to parties deprived of constitutional rights, privileges, and immunities by officio abuse of his or her position, that is to provide remedy against individual officials who violate constitutional rights. 42. USCA 5 1983. 4. Civil conspiracy. RICO 5263 42 5 1985, 2. Persons involved in litigation to be free from conspiracy. In the case of United States v. Holk, 389 F sub 2d. 338, criminal responsibility defines single or multiple conspiracies by the following: governments, without committing variance between single conspiracy charges in an indictment and its proof at trial, may establish existence at continuing core conspiracy which attracts different members at different times and which involves different subgroups committing acts in furtherance of an overall plan. This illustrates the legal analysis of the 1987 conspiracy to cover up my International Signal and Control, PLC, whistleblowing activities.
Under Pennsylvania law, conspiracy may be proved by circumstantial evidence that is by acts and circumstances sufficient to warrant an inference that the unlawful combination has been in front of facts formed for the purpose charged. See Walker v. North Wales Borough, 395 F sub 2d. 219. In the same case the following was supported: arrestees' allegations that the township, Conestoga, and its police officers were acting in concert and conspiracy and with the purpose of violating arrestees' constitutional rights by subjecting him to unreasonable force, arrest, search, and malicious prosecution, and the two or more officers acted together in throwing arrestee to the ground. April 5th th. 2006 August 4th, 2006, and 14 2. Blood test involving custody. The preceding civil conspiracy claims under Pennsylvania law. In order to state a claim for civil conspiracy and cause of action under Pennsylvania law, a plaintiff must allege it. 2. Pennsylvania law, conspiracy may be proved by circumstantial evidence that is by acts and circumstances sufficient to warrant an inference that the unlawful combination has been in front of facts formed for the purpose charged. See Walker v. North Wales Borough, 395 F sub 2d. 219. In the same case the following was supported: arrestees' allegations that the township, Conestoga, and its police officers were acting in concert and conspiracy and with the purpose of violating arrestees' constitutional rights by subjecting him to unreasonable force, arrest, search, and malicious prosecution, and the two or more officers acted together in throwing arrestee to the ground. April 5th th. 2006 and August 4th, 2006, and forcing him to take two blood tests and holding him in custody. The preceding pleaded civil conspiracy claims under Pennsylvania law. In order to state a claim for civil conspiracy in a cause of action under Pennsylvania whistleblowing activities. Under Pennsylvania law, conspiracy may be proved by circumstantial evidence that is by acts and circumstances sufficient to warrant an inference that the unlawful combination has been in front of facts formed for the purpose charged. See Walker v. North Wales Borough, 395 F sub 2d. 219. In the same case, the following was supported: arrestees' allegations that the township, Conestoga, and its police officers were acting in concert and conspiracy and with the purpose of violating arrestees' constitutional rights by subjecting him to unreasonable force, arrest, search, and malicious prosecution, and the two or more officers acted together in throwing arrestee to the ground, April 5, 2006 and August 4, 2006, and forcing him to take two blood tests and holding him in custody. The preceding pleaded civil conspiracy claims under Pennsylvania law. In order to state a claim for civil conspiracy in a cause of action under Pennsylvania law, a plaintiff must allege that two or more persons agree or combine with lawful intent to do an unlawful act or to do an otherwise lawful act by unlawful means, with proof of malice with intent to injure the person, his/her property in or business. In the case of United States v. Holk, 389 F sub 2d. 338, criminal responsibility defines single or multiple conspiracies by the following: governments, without committing variance between single conspiracy charges in an indictment and its proof at trial, may establish existence at continuing core conspiracy which attracts different members at different times and which involves different subgroups committing acts in furtherance of an overall plan. 51,983 Civil Rights Acts and 18 USCA Acts state the following: the underlying purpose of the scheme of protecting constitutional rights are to permit victims of constitutional violations to obtain redress, to provide for federal prosecution of serious constitutional violations when state criminal proceedings are ineffective for purpose of deterring violations, and to strike a balance in protection of individual RIROM state infringement and protection from state and local government from federal interference. 18 USCA 55 241, 242, USCA, Constant Art. 2, 53, amend. 13, 14, 5, 15, 52, 42 USCA 55 1981 to 1982, 1985. 1988, Federal Rules Civil PROC Rule 28, USCA. 5A Antitrust. The following violations constitute a legitimate antitrust violation under Title 15 of the federal statutes. In private antitrust actions, plaintiff, in addition to proving violations in an injury, must also show that a violation in an injury must also prove that the violation was direct and material to the cause of injury suffered. However, the plaintiff's burden in causations issues is not as heavy as the plaintiff only needs to show a causal relation with reasonable probability to a fair degree of certainty. Anderson Foreign Motors Incorporated v. New England Toyota Distributors Incorporated, D.C. Mass 1979, 475. Sup. 6 RICO. The Racketeer Influenced and Corrupt Organizations Act, commonly referred to as RICO, is a United States federal law which provides for extended penalties for criminal acts performed as part of an ongoing criminal organization. RICO was enacted by Section 901A of the Organized Crime Control Act of 1970, PUBL No. 91-452, 84 STAT 922, October 15, 1970. RICO is codified as Chapter 96 of Title 18 of the United States Code, 18 U.S.C.S. 1961 through 18 U.S.C. 5 1968. It has been speculated that the name and acronym were selected in a sly reference to the movie Little Caesar, which featured a notorious gangster named Rico. The original drafter of the bill, G. Robert Blakey, has refused to confirm or deny this. Summary. Under RICO, a person or group who commits any two of 35 crimes, 27 federal crimes and 8 state crimes within a 10-year period and, in the opinion of the U.S. attorney bringing the case, has committed those crimes with similar purpose or results can be charged with racketeering. Those found guilty of racketeering can be fined up to $25,000 and/or sentenced to 20 years in prison. In addition, the racketeer must forfeit all ill-gotten gains and interest in any business gained through a pattern of racketeering activity. The Act also contains a civil component that allows plaintiffs to sue for triple damages. When the U.S. attorney decides to indict someone under RICO, he has the option of seeking a pretrial restraining order or injunction to prevent the transfer of potentially forfeitable property, as well as require the defendant to put up a performance bond. This provision is intended to force a defendant to plead guilty before indictment. There is also a provision for private parties to sue. A person damaged in his business or property can sue one or more racketeers. There must also be an enterprise. The defendant, S, are not the enterprise. In other words, the defendant, S, and the enterprise are not one and the same. There must be one of 4 specified relationships between the defendant, S, and the enterprise. This lawsuit, like all federal civil lawsuits, can take place in either federal or state. www.daler-magazine.com exasp, Artica E equals 481. 7s 3700. Racketeering. Those found guilty of racketeering can be fined up to $25,000 and/or sentenced to 20 years in prison. In addition, the racketeer must forfeit all ill-gotten gains and interest in any business gained through a pattern of racketeering activity. The Act also contains a civil component that allows plaintiffs to sue for triple damages. When the U.S. attorney decides to indict someone under RICO, he has the option of seeking a pretrial restraining order or injunction to prevent the transfer of potentially forfeitable property, as well as require the defendant to put up a performance bond. This provision is intended to force a defendant to plead guilty before indictment. There is also a provision for private parties to sue. A person damaged in his business or property can sue one or more racketeers. There must also be an enterprise. The defendant, S, are not the enterprise. In other words, the defendant, S, and the enterprise are not one and the same. There must be one of 4 specified relationships between the defendant, S, and the enterprise. This lawsuit, like all federal civil lawsuits, can take place in either federal or state. www.dler-magazine.com exasp, article equals 481. 7s 3729. False Claims. Federal False Claims Act. The Federal False Claims Act. Title 31. Money and Finance. Subtitle 111. Financial Management. Chapter 37. Claims. Subchapter 111. Claims against the United States Government. 31 USCS 5 3729 to 33. 5 3729. False Claims. 5 3730. Civil Actions for False Claims. 5 3731. False Claims Procedure. 5 3732. False Claims Jurisdiction. S 3733. Civil Investigative Demands 5 3729. False Claims. 8 Case Law for Torture and Jurisdiction for Compensatory Damages and Remedies. United States District Court for the Southern District of Florida, Miami Division Case No. 07-21783 Civ Jordan. Teofila Ochoa Lizarb, in her individual capacity, and in her capacity as the personal representative of the estates of Silvestre Lizarb Solis, Gerardo Ochoa Lizarb, Victor Ochoa Lizarb, Ernestina Ochoa Lizarb, Celestino Ochoa Lizarb, and Edwin Ochoa Lizarb, and Cirila Pulido Baldian, in her individual capacity, and in her capacity as the personal representative of the estates of Fortunata Balda 6N Gutierrez and Edgar Pulido Balda 6N, plaintiffs. Telmo Ricardo Hurtado, defendant. The right to sue for torture. Case 1:07CV21783AJ Document 32 entered on FLSD docket February 29, 2008 page 6 of 31-7 Need to conduct and adhere to a strict choice of law analysis, RD, at 422-23. In sum, the Tachyon Court held that both federal law and international law apply to ATS and TVPA claims. The Ninth Circuit also conducted an examination of the applicable choice of law for damages in ATS cases, in Alvarez-McCain v. United States 331 F.3d 604, 9th CIR, 2003, revved on other grounds, Sosa v. Alvarez-McCain, 542 U.S. 692, 2004. After finding that federal common law applies to the choice of law determination, the court held that it should first look to the restatement, second, of conflict of laws, which states that choice of law principles in tort law are governed by the most significant relationship test. Road at 633-34. Citing Section 145 Restatement 56. In order to determine what law has the most significant relationship to the tort, the restatement looks to the following factors. A. The place where the injury occurred. B. The place where the conduct causing the injury occurred. C. The domicile, residence, nationally the relationship, if any, between the parties is centered. RD. At 634. The court then articulated competing policy factors that should be considered in ATS cases. These factors included: A. The needs of the interstate and international systems. B. The relevant policies of the forum. C. The relevant policies of other interested states and the relative interests of those states in the determination of sup. The particular issue. D. The action of justified expectations. E. Basic policies underlying the particular field of law. F. Certainty, predictability, and uniformity of result. And G. Ease in the determination and application of the law to be applied. Road at 634, citing Section 145 Restatement 56, 2. The Alvarez-McCain Court held that the totality of the factors, including the policy of the United States, as expressed in the ATCA, to provide a remedy for violations of the law of nations, weighed in favor of applying United States law. Road Case 1:07CV21783AJ Document 32 entered on FLSD docket February 29, 2008 page 7 of 31-8. The federal common law analysis articulated in these precedents favors the underlying trumped by federal law where the applicable law is inconsistent with federal common law. As a practical matter, this means that federal courts typically apply federal common law to damages under the ATS. Here, under 11th Circuit precedent, federal common law would apply to the determination of damages under the ATS. Under the analysis articulated by the Tachyon Court, the law of nations and federal common law would apply to the damages inquiry under the ATS. Tachyon at 419-20. Under the Alvarez-McCain standard, the most significant relationship test favors the application of Peruvian law, but the relevant Pollock considerations articulated in the decision favor the application of federal common law. The totality of the case law, thus, weighs in favor of applying federal common law to the determination of damages under the ATS. This court should award plaintiffs damages under federal common law for their ATS and TVPA claims. Jurisdiction for compensatory damages and remedies. Federal common law on damages. Once it has been determined that federal common law applies to the question of damages, it becomes necessary to determine how to ascertain what the federal common law of damages is, as it relates to damages under the ATS and the TVPA. In order to determine or to fashion federal common law remedies, courts may be guided by appropriate statutes without adopting any in their entirety. See Park v. Korean Airlines Co., 1992 USDIST Lexus 16841, 20, SDNY 1992, citing Moraine v. State Marine Lines Incorporated, 398 US 375, 406 to 408, 1970. 3. This is true under both the ATS, which is simply a jurisdictional grant of that enables plaintiffs to bring claims for violations of established international law, and under the TVPA, which creates a specific cause of action for claims of torture and extrajudicial killing. In each case, absent the federal statute, plaintiffs would have no ability to sue in federal court. For the application of federal common law to damages under ATS and TVPA cases is also supported by legal commentators. International human rights litig. In U.S. courts states that in ATS litigation, THE remedy, however, is a purely domestic tort remedy governed by traditional, well-established concepts of federal common law. Beth Stevens, International Human Rights Litigation in U.S. Courts, Brill Publishers 2008, citing William R. Casto, The New Federal Common Law of Tort Remedies for Violations of International Law, 37 Rutgers LJ 635, 641, 2006. Wright and Miller states that courts should look to a wide variety of sources, including considerations of what rule is best designed to implement the underlying federal policy or statute involved and general considerations of equity jurisprudence. Wright and Miller, Federal Practice and Procedure 5 4518. Although some courts conceptualize this broad inquiry as a choice of law analysis, they only follow choice of law principles to the extent those principles are consistent with the federal common law policy objective enforcing the intent of the ATS. Most federal court decisions that perform any choice of law analysis do so in the context of an inquiry over other aspects of ATS law. Conclusion. The petition for a writ of certiorari should be granted. Respectfully submitted. Date, November 10, 2018. Freedom from covert. The mental health history and the criminal records were completely fabricated, and a close review and investigation into the actual court records and hospital records can prove that in very short fashion. There are two ways to quickly dispute the mental health history and record. 1. Review the word, delusional, delusions, etc., every instance of the word used by mental health professionals, and the false reports by friends and family were associated with facts and matters of the official record, the complete opposite of the meaning of the word, delusional. And they still exist to this very day. 2. Review the 3 fabricated suicide allegations of the following dates. August 87 at Burdett Tomlin Hosea, Cape May County, New Jersey, February 18 th, 2005 by Kerry Egan and the Southern Regional Police Department, and July 19, 2009 for the 302 commitment by the Lancaster City Police Department at Lancaster General Hospital. The criminal record is very similar. Since 1987 Stanley J. Caterbone has had 31 false arrests, formal charges and convictions dismissed prior to court proceedings or one on summary appeals in the county of Lancaster, Pennsylvania, most of which Stan J. Caterbone appearing as pro se, representing himself. These have resulted in civil complaints filed in 2008 in Caterbone v. the County of Lancaster, Pennsylvania and U.S. District Court for the Eastern District of Pennsylvania. Conclusion. The petition for a writ of certiorari should be granted. Respectfully submitted. Date, November 10, 2018. Freedom from harassment and surveillance. Registered in Pennsylvania 1250, Fremont Street, Lancaster, Pennsylvania, 17603 www.amgglobalentertainmentgroup.com stancaterbone@gmail.com 717-327-1566 A lump sum for the victim's medical expenses during her incarceration. A sum corresponding to the travel expenses incurred by the next of kin to visit the victim while she was held in detention. An amount corresponding to the likely future medical expenses of the victim and her children. As for compensatory damages, Peru was ordered to pay a total of $167,190 and 30 cents for the victim, $20,000 for the victim's parents, $30,000 for the victim's children, $18,000 for the victim's brothers. Importantly, and relevant as comparison practice in relation to correction for torture practices were the institutional reform and measures required to prevent recurrence of violence by the IACR. Peru was required to adopt all internal legal measures necessary to adapt Decree Laws 25,475, Crime of Terrorism, and 25,659, Crime of Treason, to conform to the ACHR. Peru was mandated to investigate the facts in the applicant's case, and identify and punish those responsible for those acts, and adopt all the necessary domestic legal measures to ensure that this obligation is discharged. The justices also required the state to take all measures necessary to reinstate Ms. Loaiza de Mayo in the teaching service of the university from which she had been fired. This reinstatement was also based on the understanding that the amount of her salaries and other benefits would be equal to the pay she was receiving for the teaching at the time she was detained, with appreciation to the date of the IACR's decision. Down to the specifics, Peru was required to guarantee Loaiza de Mayo her full retirement benefits, including those owed for the period that followed her detention. Another relevant case as we survey the international jurisprudence for torture is that of Cantoral Benavides case v. Peru, 2001. This case is valuable because the remedies given reflect the court's understanding of the long-term medical needs of the Luis Alberto Cantoral Benavides following torture experienced in custody. Cantoral Benavides was a 20-year-old university biology student when he was arrested. He was detained for 4 years and after release he experienced ongoing physical and psychiatric complaints. Reparations to Cantoral Benavides included US $24,000 which was calculated to compensate the salary he would have received if not imprisoned. For medical treatment received in custody he was awarded US $1,000 and for future medical treatment the court allocated US $10,000. In a distinctly egalitarian move, appreciating the parallel harms that are experienced by the families of those tortured, the court found that Cantoral Benavides' mother suffered and still evidenced symptoms physical and psychological pain originating from the imprisonment and situation of her son. In this instance of extended reparation the court ordered Peru to pay US $1,500 for medical treatment. A parallel sum was also awarded to Cantoral Benavides' brother for medical and psychological aid. Moral damages were paid to the primary victim, his mother, and his 3 brothers, $125,000. In terms of institutional reparation the state was ordered to annul any domestic criminal, administrative or judicial records against the victim. Notably the court ordered that the merits judgment of the court be published in a national legal journal. The state was required to make public amends to the victim including providing a scholarship for graduate studies with a monthly fee for living expenses. All medical costs for the victim's mother were to be paid by the state. These IACR cases are illustrative of a broader trend to transformative reparations where serious human rights have been engaged by the state. Increasingly, it is simply insufficient to compensate the victim financially when non-derogable human rights are violated, though that is an essential first step of repair. Rather, regional human courts have recognized that the imprint of the harm of torture is lifelong, life-changing, and affects the lives of families as well as of the persons whose bodies and integrity have been violated. In this context, the response of the United States to the probing of the UN Committee on Remedies seems woefully inadequate. While having provided the committee with the names of 33 individuals who had filed claims against the Department of Defense, no substantive information was provided on the status of those cases. Despite questions asked by the committee, the U.S. delegation neatly avoided giving information on whether any of those individuals had been provided non-judicial remedies, and on the numbers of lawsuits involving torture or serious ill treatment that had failed. To proceed on the basis of non-exhaustion of the internal grievance system. Despite the Sup. Apparent formal assurances Robin Jacobson, Associate Deputy Attorney General, there is no evidence that the United States has taken responsibility to implement remedies for acknowledged torture. He stated, U.S. law provides a wide range of civil remedies for seeking redress in cases of torture. These include injunctions, compensatory damages, punitive damages, and declaratory relief. In addition, the U.S. Congress has authorized the federal government to bring civil actions to enjoin acts or patterns of conduct that violate constitutional rights, including those that would amount to torture. At the federal level, the principal avenues of individual redress are administrative tort claims and civil litigation. Common law tort actions for assault, battery, wrongful death, civil actions for violations of federally protected civil rights, suits based on federal constitutional rights. On the state level, all of our states provide for civil tort suits to be brought against state officials and many permit damages for violations of state constitutional rights. This formal litany of effectively unavailable rights to tortured Guantanamo Bay detainees and others operates as a secondary layer of convention violation. Namely, the violation of the right to an effective remedy for torture. Words in fact, may be cheap. As Gabor
Rona has noted here, there is little new about the acknowledgement of extraterritoriality official by this U.S. delegation, despite the hype. Harold Koh, among other commentators here, has applauded the honesty and increased transparency of the acknowledgements made before the committee, a cheer for the unequivocal yes. On that matter, I am less persuaded. There is a grave danger that acknowledgement may blur the ongoing, daily violations of detainees' human rights. It may also cloud and allow us to forget that there are a host of other obligations that follow from naming the fact that torture has taken place. Lest we forget, the United States has a direct obligation to each individual tortured and subject to cruel treatment at Guantanamo Bay, and that obligation is one of repair, remedy and restitution. 11 Justice for Victims of Torture and Terrorism Act. House Report 110-844 from the U.S. Government Publishing Office. 110th Congress Report House of Representatives 2D Session 110-844. September 15, 2008 committed to the Committee of the Whole House on State of the Union and ordered to be printed. Mr. Conyers, from the Committee on the Judiciary, submitted the following report to accompany H.R. 5167 including cost estimate of the Congressional Budget Office. The Committee on the Judiciary, to whom was referred the bill, H.R. 5167, to amend the National Defense Authorization Act for fiscal year 2008 to remove the authority of the President to waive certain provisions. Having considered the same, reports favorably thereon with amendments and recommends that the bill as amended do pass. Other. E. In the Supreme Court of the United States. Petition for writ of certiorari. Asterisk petitioner R. Respectfully prays that a writ of certiorari issue to the judgment, below. Opinions below. 4 cases from federal courts. The opinion of the United States Court of Appeals appears at Appendix and A to the petition and is X. At 11th Circuit Court of Appeals. Th has been designated for publication but is yet reported, or is unpublished. The opinion of the United States District Court appears at Appendix A. 2. The petition and is U.S. District Court for Southern Florida reported at H as Berry designated for publication. Bulletin T is not yet. Is unpublished. 4 cases from state courts. The opinion of the highest state court to review the merits appears at Appendix to the petition and is I has been designated for publication, but is NOL, yet reported, or is unpublished. The CBIN ion of the court appears at Appendix, to the petition and is reported at has he been designated FOI publication hut asterisk is riot, yet, reported, it is, umublia head. 1. Supreme Jurisdiction. 4 cases from federal courts. The date on which the United States Court of Appeals decided my case was September 21, 2018. I know petition for rehearing was timely filed in my case. A timely petition for rehearing was asterisk denied by the United States Q+T of Appeals on the following date, September 21, 2018, and copy of the order denying rehearing appears at Appendix A. An extension of time to file the petition for a writ of certiorari was granted to and including date on in application no. ZA. The jurisdiction of this court is invoked under 28 UISCS 1254, 1. 4 cases from state courts. The date on which the highest state court decided my case was a copy of that decision appears at Appendix. A timely petition for rehearing was thereafter denied on the following date. And a copy of the order denying rehearing appears at Appendix J. An extension of time to file the petition for a writ of certiorari was granted to and including date on date Lin application no. A. The jurisdiction of this court is invoked under 28 U.S.C. E. Constitutional and statutory provisions involved. Amendment V. 5 Rights in criminal cases. No person shall be held to answer for a capital, or otherwise infamous crime, unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces, or in the militia, when in actual service in time of war or public danger, nor shall any person be subject for the same offence to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property, without due process of law, nor shall private property be taken for public use without just compensation. Amendment 6. 6 Rights to a fair trial. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial, by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. Amendment VLL, 7 Rights in civil cases. In suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States, than according to the rules of the common law. Amendment VLLL, 8 Bails, fines, and punishments. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. Tatement of the Law. As of today there have been 307 mass shootings in 313 days in the United States of America of 4 or more persons, almost 1 per day. I have filed amicus briefs for two of the mass shooters and have an amicus pending for the Washington state bomber that sent bombs in packages to military installations in and around Washington, D.C. I have had a scheduled conference call with the legal firm representing families of the Las Vegas mass shooting after they reviewed a few of my documents. There are at least 3 mass shooters that have died, where amicus briefs would have been moot. The amicus briefs that I do file are done after As of today there have been 307 mass shootings in 313 days in the United States of America of 4 or more persons, almost 1 per day. I have filed amicus briefs for two of the mass shooters and have an amicus pending for the Washington state bomber that sent bombs in packages to military installations in and around Washington, D.C. I have had a scheduled conference call with the legal firm representing families of the Las Vegas mass shooting after they reviewed a few of my documents. There are at least 3 mass shooters that have died, where amicus briefs would have been moot. The amicus briefs that I do file are done. Research and analysis reveals the common denominators of persons like myself that make claims of US-sponsored mind control technologies. I have witnessed these traits since I was about 5 or 6 years old in my father, then with my brother until one became a victim. Are you people certain you are making the right decisions to keep this country safe? Are you able to look into the eyes of the crying fathers, mothers, friends, and relatives of those murdered in these mass shootings with the utmost confidence in your decisions regarding my cases? On December 4, 2017 in the United States District Court, Southern District of Florida before the Honorable Judge Beth Bloom, Case No. 17-60022 Crim Bloom Pro Se Petitioner Stan J. Catterbone's application for amici curiae brief was denied. Judge Bloom wrote, "This cause is before the court upon a sua sponte review of the record." On December 1, 2017, Stanley J. Caterbone and Advanced Media Group, amici curiae, filed documents Pro Se with the court styled as an application for amici curiae brief. Applications. ECFNOS 76 and 77. The stated purpose of the applications are that it was filed in support of Esteban Sic Santiago Ruiz Sic Defense RD. As part of the application submission, amici curiae submitted a DVD because printing of the DVD materials are of the utmost importance to this amicus brief and it would be cost prohibitive to print in paper format RD. The court has carefully reviewed all the information submitted by amici curiae, including the electronic information contained on the DVD and finds as follows. Amicus curiae means friend of the court. A person with strong interest or views on the subject matter of an action may actually petition the court for permission to file a brief, ostensibly on behalf of a party but to suggest a rationale consistent with its own views. Black's Law Dictionary 75, 5th ed. 1979. News and Sun Sentinel Co. v. Cox, 700 F. Sup. 30, 31, SD. FLA, 1988. The rule is well established that a corporation is an artificial entity that can act only through agents, cannot appear pro se, and must be represented by counsel. Commercial and Railroad Bank of Vicksburg v. Slocum, 39 U.S., 14 Pet. 60, IOL.ed. 3154, 1840. As the court is denying the application on the merits, it declines to consider the implications of this prohibition here. Me. While Federal Rule of Elite Procedure 29 provides for the of amicus curiae briefs, the Federal Rules of Civil Procedure lack a parallel provision regulating amicus appearances at the district court level. District courts have inherent authority to appoint or deny amici, which is derived from Rule 29 of the Federal Rules of Appellate Procedure. See Mobile CNTY. Water, Sewer and Fire Prot Auth Inc. v Mobile Area Water and Sewer SYS, Inc., 567 F, Sup. 2D 1342, 1344, SD ALA 2008. Inasmuch as an amicus is not a party and does not represent the parties but participates only for the benefit of the court, it is solely within the discretion of the court to determine the fact, extent, and manner of participation by the amicus. Cox, 700 F Sup at 31. Citation omitted. The decision whether to allow a non-party to participate as an amicus curiae is solely within the broad discretion of the court. Resort Timeshare Resales Incorporated v. Stewart, 764 F. Sapere $149, 1500, S.D.FLA 1991, Ellsworth Essex, Inc. v. United States. 917 F. Sup. 841, 846, D.D.C.1996. To be sure, the instant case is of public importance. However, this case is a pending criminal trial ** as such. It is noteworthy that there are specific constitutional protections that exist in criminal cases that do not otherwise apply to parties in civil actions. See United States v. Ward, 448 U.S. 242, 248, 1980. Moreover, Mr. Santiago Ruiz is represented by learned counsel as required by 18 U.S.C. 53005, as well as 3 other qualified and experienced attorneys from the Federal Defender's Office. There has been no suggestion or reason to believe that appointed counsel cannot or will not adequately represent Mr. Santiago Ruiz. There is no indication that counsel requested or encouraged assistance from the amici curiae. 2. It is rare for amicus curiae briefs to be filed in criminal cases even at the appellate level. Over the 5 years from 2003 to 2007, only 12 amicus curiae briefs were filed in criminal cases. P. Stephen Gidier ill. The Facts and Fictions of Amicus Curiae Practice in the 11th Circuit Court of Appeals, 5 Seton Hall Circuit Rev. 1, 18, 4008. Further, the court does not find the participation of amici curiae would be desirable or beneficial to these proceedings. Courts typically grant amicus status where the party contributes to the court's understanding of the matter in question by proffering timely and useful information. Conservancy of Southwest Florida v. U.S. Fish and Wildlife Servo, No. 2, 10 CV 106, 2010 WL 360, 3276 at *1, M.D.FLA September 9, 2010. There is nothing in the applications to indicate that the amici curiae offers timely or useful information relevant to the instant case. It is ordered and adjudged as follows. Stanley J. Caterbone and Advanced Media Group's applications for amici curiae brief. ECFNOS 76 and 77 are denied. Done and ordered in chambers at Miami, Florida, on December 4, 2017. On January 8, 2018 ANE of amended appeal was recorded United States Court of Appeals for the 11th Circuit Case No. 18-10134 Re United States of America v. Stan J. Caterbone. On January 29, 2018 the United States Court of Appeals for the 11th Circuit Case No. 18-10134 Re United States of America v. Stan J. Caterbone coming from the United States District Court, Southern District of Florida issued a jurisdictional question to all parties. Jurisdictional question. Please address under which theory is the District Court's interlocutory order denying interested party Stan Caterbone's motion to file an amicus brief immediately appealable. See 28 U.S.C. 51291. In addition, please address whether Mr. Caterbone has standing to appeal from the District Court's order. See Wolfoff. Cash 4 titles, 351 F.3d 1348, 1353-58, 11th Sir 2003. On February 3, 2018 Pro Se petitioner Stan J. Caterbone filed a brief swearing the jurisdictional question. On June 4, 2018 before William Pryor, Jordan, and Julie Carnes, circuit judges the appeal to the 11th Circuit Court of Appeals was dismissed by the court. In light of the responses to the jurisdictional question, we dismiss this appeal for lack of jurisdiction. Stan J. Caterbone, proceeding Pro Se, has appealed from an interlocutory order denying his motion for leave to file an amicus brief in a pending criminal case brought by the government against Esteban Santiago Ruiz. We lack jurisdiction because Caterbone does not appeal from a final order or an order that is immediately appealable under a statute or jurisprudential exception. See 28 U.S.C. 55 1291, 1292, CSX Transp, Inc. v. City of Garden City, 235 F.3d 1325, 1327, L. Sir 2000, noting the general rule that this court's jurisdiction is limited to appeals from final orders under 5 1291 or interlocutory orders appealable under statute or jurisprudential exception. In addition, only a litigant who is aggrieved by a judgment or order may appeal it. Wolf v. Cash 4 titles, 351 F.3d 1348, 1353, 11th Sir 2003. A non-party ordinarily lacks standing to appeal an order from that case, and even parties may lack standing to appeal trial court rulings that do not affect their interests. Wrote at 1354. Standing requires a person to have suffered an injury in fact that is concrete and particularized, actual or imminent, and not conjectural or hypothetical. Lujan v. Defenders A/Wildlife, 504 U.S. 555, 560, 1992. Here, the order denying Catterbone's request does not affect his interests in a way sufficient to confer standing to appeal. See Lujan, 504 U.S. At 560, Wolf, 351 F.3d at 1353. On September 21, 2018 in the United States Court of Appeals for the 11th Circuit Case No. 18-10134 Re United States of America v. Stan J. Catterbone coming from the United States District Court, Southern District of Florida, before William Pryor, Jordan, and Julie Carnes, Circuit Judges. The motion for reconsideration was denied by the court. Me. Stan J. Catterbone LSMO for reconsideration of our June 4, 20 dismissing this appeal for lack of jurisdiction is denied. All other pending motions are denied as moot. Background of PETINA Stan J. Catterbone, SE Petitioner Stan J. Catterbone is a private citizen and the majority shareholder of the United States Incorporated Business Advanced Media Group, Limited. Pro SE Petitioner Stan J. Catterbone was a whistleblower and shareholder in 1987 involving the United States defense contractor International Signal and Control, PLC, known as ISC. In 1992, International Signal and Control was indicted and found guilty of among other things $1 billion fraud and export violations concerning illegally shipping cluster bomb technologies, missile defense systems, and other defense systems to foreign interests including South Africa, Iraq, and Saddam Hussein. Cluster bombs and related technologies are known to have been exported to Iraq by the Chilean arms dealer Carlos Cardoen, a joint venture partner of International Signal and Control. The Central Intelligence Agency is confirmed to have been involved in a covert program to arm Iraq during the 1980s with close ties to International Signal and Control, which allegedly included the help of the National Security Agency, a former end user of International Signal and Control technologies under the early 1980s program Project X. A presidential finding in 1984 by the Bush administration was executed to implement the program of arming Saddam Hussein and Iraq with the cluster bomb technologies. Serious allegations of these programs were the focus of investigations that included the knowledge and supervision of then-appointed nominee for the Director of Central Intelligence Agency, Robert M. Gates. Since 1987, Pro SE Petitioner Stan J. Catterbone has been the victim of vast civil conspiracy that started in 1987 to cover up allegations of fraud within International Signal and Control during the negotiations and merger of International Signal and Control and Ferranti International of England. Stanley J. Catterbone alleges that warrantless surveillance was used to obstruct justice and moot his constitutional rights in an effort to divert attention away from his allegations of fraud within International Signal and Control back in 1987, and afterwards to the present as a means to deny his access to the courts for remedy and relief, and Federal False Claims Act violations. The business of Advanced Media Group has been greatly compromised and intellectual property stolen during the late 1980s and early 1990s that included information technology contracts with the United States government. Organized stalking and harassment began in 1987 following the public allegations of fraud within ISC. This organized stalking and harassment was enough to drive an ordinary person to suicide. As far back as the late 1980s, Pro SE Petitioner Stan J. Catterbone knew that his mind was being read, or remotely viewed. This was verified and confirmed when information only known to him, and never written, spoken, or typed, was repeated by others. In 1998, while soliciting the counsel of Philadelphia attorney Christina Rainville represented Lisa Michelle Lambert in the Laurie Show murder case, someone introduced the term remote viewing through an email. That was the last time it was an issue until 2005. The term was researched, but that was the extent of the topic. Remote viewers may have attempted to connect in a more direct and continuous way without success. In 2005, the US-sponsored mind control turned into an all-out assault of mental telepathy, synthetic telepathy, and pain and torture through the use of directed energy devices and weapons that usually fire a low-frequency electromagnetic energy at the targeted victim. This assault was no coincidence in that it began simultaneously with the filing of the federal action in U.S. District Court, or Catterbone v. Lancaster County Prison, E.T. AL, or 05CV2288X. This assault began after the handlers remotely trained Stan J. Catterbone with mental telepathy. The main difference opposed to most other victims of this technology is that Stan J. Catterbone, after being connected to some 20 or so individuals ranging from CIA operatives to current-day national newscasters and celebrities, Stan J. Catterbone remains connected 24/7 with a person who declares that she is Interscope recording artist Sheryl Crow of Kennett, Missouri. Stan J. Catterbone has spent 3 years trying to validate and confirm this person without success. Most U.S. intelligence agencies refuse to cooperate, and the Federal Bureau of Investigation and the U.S. Attorney's Office refuse to comment. See attached documents for more information. In 2006 or the beginning of 2007, pro-SE petitioner Stan J. Caterbone began his extensive research into mental telepathy, mind control technologies, remote viewing, and the CIA mind control program labeled MK-Ultra and its sub-programs. In January of 2006, pro-SE petitioner Stan J. Caterbone was detained at every airport security checkpoint, which was during a policy of random checks, and taken out of line during travel from Philadelphia, Pennsylvania, to Houston, Texas, and on to Puerto Vallarta, Mexico. At the Houston airport, Stanley J. Caterbone was falsely accused of carrying plastics explosives and taken to an interview room by Homeland Security officials. J. Caterbone was also detained for days in Mexico, and was not provided with an opportunity to gain access to a flight out of the country by Mexican officials. Today, pro-SE petitioner Stan J. Caterbone is a pro-SE litigant in several state and local courts, in an effort to be restored to whole since the whistleblowing of 1987. Most notable is Caterbone v. the National Security Agency, NSA, et al. In the United States Court of Appeals for the Third Circuit case No. 17-1904. That case is a preliminary injunction for emergency relief filed to immediately halt the obstruction of justice that is being administered through the illegal COINTELPRO program coupled with the torture program. The following is a memo of a meeting with ISC executive Mr. Lawrence Resch and Mr. Pro-SE petitioner Stan J. Caterbone at his office at Financial Management Group, Limited, which took place on June 23, 1987. Mr. Lawrence Resch, of San Clemente, California, was a longtime associate of Mr. James Guerin, who worked as a marketing consultant, and was an ISC executive prior to the company going public in 1982. He served as Director of Marketing and Head of Lancaster Operations for then-defunct United ChemCon, an affiliate of ISC. He was sued by Ferranti International in 1990 for $189 million and indicted and found guilty by prosecutors for his role with ISC and served a jail term. Upon the arrival of Mr. Larry Resch, Stan Caterbone met him in the lobby of Financial Management Group, Ltd., at which time Larry Resch said Carl Jacobson could not attend. We had to suddenly fly him out of the country early this morning, flew to Chile. The meeting was started with the subject of the financial difficulties of United ChemCon and possible alternatives. Larry Resch specifically addressed the possibility of moving the operations of United ChemCon to another facility, with specific regards to the Renovo plant. Larry Resch specifically addressed the financing capabilities of Stan Caterbone, along with possible management opportunities. Larry Resch also gave financial statements and documents to Stan Caterbone for the latest fiscal year for United ChemCon. Stan Caterbone went on to allege that United ChemCon had embezzled some $15 million from the United States government for contracts that contained improprieties. Stan Caterbone also alleged improprieties of International Signal and Control and James Guerin, with specific regards to its role in the United ChemCon, and its business activities as related to government contracts. Stan Caterbone noted that he, as a legal shareholder of International Signal and Control, was concerned about improper business activities. Larry Resch was taken by surprise by all of the above. Stan Caterbone became quite upset by the evasiveness and the lack of specifics with regards to Larry Resch's conversation. In efforts to thwart any further communication from James Guerin, United ChemCon, or International Signal and Control, Stan Caterbone demanded a retainer fee of $10,000 before anyone contacted him again. Today, the Trump administration is using the old Edgar Hoover COINTELPRO program while at the same time expanding the powers of local law enforcement through 3 executive orders in order to militarize local police departments. The following are the effects of the illegal and landmark COINTELPRO program that is used against me. As contained in the Lancaster County Court of Common Pleas Case No. 08-13373, where President Donald Trump was added to the defendants list on January 23, 2017, and other state and federal court cases, the Trump administration is utilizing an illegal COINTELPRO program to harass the appellant, Stan J. Caterbone, and obstruct justice by causing it almost impossible for the continuation of those same civil actions. The Trump administration signed 3 executive orders that broadened the powers of the City of Lancaster Police Department to coincide with the above. The fact that complainant Stan J. Caterbone's history with the Lancaster City Police Department traces back to the 1960s with the targeting of complainant Stan J. Caterbone's father, Samuel Caterbone, Jr. in the very same manner as the current targeting of complainant Stan J. Caterbone today is reason enough to have summary judgments in all civil actions in federal and state courts immediately ordered. The targeting consists of the following: an unprecedented harassment program carried out by residents, neighbors, stalking groups, law enforcement, and others. An unprecedented hacking program of all electronic equipment. Unprecedented torture program utilizing electromagnetic and other exotic weapons developed by the Department of Defense and Intelligence Community. An unprecedented campaign designed to drain the appellant Stan J. Caterbone of all cash resources, which has resulted in a cash position of some $60,000 in June of 2015 to nothing today. The unprecedented campaign of false statements by the residents of 1252 Fremont Street and the perjured statements of Lancaster City Police in recent criminal summary offenses filed in District Magistrate Adam Whitconey's court. An unprecedented campaign of daily harassment and threats by the residents of 1252 Fremont Street, which has been ongoing since 2006. An unprecedented campaign of threats of physical harm in public spaces. The unprecedented campaign of the breaking and entering into the residence of the complainant Stan J. Caterbone, causing vandalism, thefts, poisoning of food, and the strategic placement of cockroaches on a daily basis. This also involves the theft and manipulation of court filings and evidence. The above are all facilitated and supported with violations of due process in the complaints to law enforcement. Complainant Stan J. Caterbone, pro seem receiving retaliatory adverse and harassing treatment due to the fact that 1. Complainant Stan J. Caterbone, pro set am the amicus for former Pennsylvania Attorney General Kathleen Kane in case number 3575 EDA 2016 in the Eastern District of Superior Court, currently in litigation. The cumulative results of the above lays the foundation for an unprecedented landmark case of human rights violations and antitrust violations. It is too easy for present and future administrations to abuse their power and utilize warrantless surveillance as a means of subverting and obstructing justice for those that are engaged in whistleblowing cases that concern national security. Without the proper oversight and judicial review, a whistleblower can be placed on terrorist lists for malicious reasons without the knowledge or just cause. This is in direct conflict with keeping our democracy free of corruption while adhering to the spirit of the Constitution in the manner our founding fathers envisioned. Activists, citizens, and voters must ensure that constitutional rights of private citizens are not compromised and justice subverted through information obtained from warrantless surveillance upon which there is no just cause for any allegations or association with terrorism. Whistleblowers are inherently supportive of a system of checks and balances within our government that go beyond our constitutional doctrines regarding the same. Whistleblowers ensure that the rule of law is universally applied to all government officials in all branches of government. The Federal False Claims Act and its provisions protect individuals from abuse of power, while providing relief and remedies for those that were wronged and those that had the courage to cite a wrong. U.S.-sponsored mind control systems are also used to complement these illegal programs to silence whistleblowers and others that our government recognizes as a threat to their illegal strategies and those that are seeking the truth. Synthetic telepathy coupled with electromagnetic weapons used for pain have been the electronic weapons of choice by the perpetrators committing these heinous crimes against Stan J. Caterbone since at least 2005. My father, U.S. Navy 1943–1946, was a victim of MK Ultra and experienced the same effects since at least the early 1960s, and my brother, Sammy, U.S. Air Force 1969–19710, received the same victimization through the use of the LSD experiments of the same program. Pro-SE petitioner Stan J. Caterbone stated and declared that the initial time of connection with the synthetic telepathy consisted of months of non-stop interrogations by male subjects who identified themselves as CIA operatives. The interrogations lasted hours upon hours at a time and covered just about every aspect of amicus Stan J. Caterbone's life. The handlers, for lack of a better term, not only focused on the whistleblowing activities of ISC in 1987, but also covered mundane everyday experiences, as a form to harass and torture. In late spring of 2005, the handlers introduce females to the sessions. To this day, the torture consists of the same, interrogations mixed in with harassment, sex, and humor. It is the opinion of pro-SE petitioner Stan J. Caterbone, that the only way to keep from desensitizing and numbing to the harassment and pain is to experience pleasure and laughter so as to keep the magnitude of the pain at its highest level. This can be substantiated and validated by the fact that the Social Security Administration under Health and Human Services granted pro-SE appellant debtor Stan J. Caterbone disability benefits in August of 2009 for symptoms and illnesses related to U.S.-sponsored mind control, and in fact stated in the award letter that disability was determined to begin in December of 2005, the date a pro-SE petitioner Stan J. Caterbone declared that the synthetic telepathy had gone full-time 24/7, without interruption, to this day. REANS for granting the it. Argument 1. Craig Stedman, Lancaster County District Attorney was /is a former military intelligence officer. Coincidence that pro-SE petitioner Stan J. Caterbone has had over 30 arrests dismissed, most prior to any hearings or trials since 1987, leading to false arrests and malicious prosecutions? From the Pennsylvania Coalition for Civil Justice Reform Judicial Candidate Questionnaire. Do you believe our judicial system adequately deters and penalizes frivolous litigation? If not, what reforms would you like to see? Please see my previous response. I would add that I have been subject to numerous frivolous lawsuits from people I have prosecuted. My office, and the county, has had to spend considerable resources fighting what were clearly vindictive and retaliatory lawsuits from criminal defendants, so I certainly can identify with concern in this area. Law School. Office of the Secretary of Defense Honors Legal Internship. Washington, D.C. Todd, Gemmell, Nugent, and Fitzgerald, Linwood, New Jersey. Military. United States Army Intelligence Center and School. Officer Basic Course, FT Huachuca, Arizona, 1987. Graduated first in class in academics. ECA. Wrongful prosecutes and false arrests. September 1, 1987. September 3, 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 1987. CC 2706 Terroristic Threats ML quashed/dismissed/demur SUS. CC 2902-1 Unlawful Restraint ML quashed/dismissed/demur SUS. CC 3304-2 Criminal Mischief F3 null prost/withdrawn. CC 33502 Burglary, FL none prost/withdrawn. CC 370101 Robbery FL null prost/withdrawn. CC 3921 A Theft by Unlaw Attack F3 null prost/withdrawn. CC 3933-1 Unlaw Use Comp F3 null prost/withdrawn. December 5, 2006 118 55503 SSA2 Disorderly Conduct Unreasonable Noise/withdrawn. December 5, 2006 118 53926 55A4 Theft of Services Acquisition/withdrawn. December 5, 2006 118 52709 55A7 Harassment Repeat in Manner/withdrawn. January 18, 2007 1. January 18, 2007 1. January 23, 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 2007 1. April 30, 2007 1. April 30, 2007 2. April 30, 2007 1. April 30, 2007 1. May 10, 2007 M2. May 10, 2007 3 M1. May 29, 2007 1. 75S 1543 55A Driving while OPER priv suspension or revoked/withdrawn. 75-5 1786 55F Driving without required insur/withdrawn. 285-21D No parking or stopping permitted/withdrawn. 285-30 A meter violation/withdrawn. 18-5 6501 55 Al scatter rubish upon land/withdrawn. 285-21D No parking or stopping permitted/withdrawn. 285-30 A meter violation/withdrawn. 18-5 5503 55A4 Disorderly conduct hazardous/physical off not guilty. 18S 5507 SSA Obstruction of highway/not guilty. 1850 2709 55A7 Harassment repeat in manner/not guilty. 75-5 3111 SSA Disregard traffic control device/not guilty. 18-5 5104 Resist arrest/other law enforcement/withdrawn. 18-5 1543 55 Make rep/sell/etc. off weep/null pros. 75-5 1543 55A Driving while OPER priv suspension or revoked/not guilty. November 1, 2007 S75S 3714 55A Careless driving/null pros. November 1, 2007 S75 5 3802 55 Al DUI, Gen Imp/Inc of drive safely/null pros. July 3, 2008 TR 000185-08 Driving under suspension by PA State Police/erased records wrong. July 3, 2008 TR 000185-08 DUI charge by PA State Police/erased records wrong. Charges were from a county outside Pittsburgh, Pennsylvania, and the real defendant had the same July 15 birthday and last name starting with Cat. February 2018 harassment charge before MDJ Spunuggle. 0. Argument 2. For the first time, a YouTube video appeared on a website of a 2014 interview of Edward Snowden by Brian Williams and NBC News outlining an NSA program of remote neural monitoring. The following is the link to that interview. Remote neural monitoring, how they spy on your thoughts. Anonymous http://www.anonnews.co/spy-on- http://www.anon-use.co/spy-your-thoughts/number-discuss_thread. How many times did you have thoughts that you never wanted to share with anyone, and have been constantly worried at the thought of someone ever finding out about these thoughts? All of us have been through this process, and the new and improved technologies being developed around the world, supposedly to deal with crime and terrorism, and inadvertently intrude on one's privacy, should probably bring us all to the brink of paranoia. These technologies are funded by governments at the highest level, and some of the countries involved include USA, Russia, China, UK, Spain, Germany, and France. RNM works remotely. Ever wondered why have we all been driven relentlessly towards wireless systems, to control the brain under the objective to detect any criminal thought taking place inside the mind of a possible culprit? Inevitable question, how can you isolate a criminal thought if you do not have a comparative measure of non-criminal thoughts? This undertaking is based on two principles. The research studies have shown that the humanoid intellect thinks at a speed of about 5 kilobits per second and, therefore, does not have the capability to contest with supercomputers acting via satellites, implants and biotelemetry. The human brain has a characteristic set of bioelectric resonance structure. By using supercomputers, the RNM system can home in on it, and send messages through an embedded individual's nervous system in order to affect their performance in a preferred way. The entire system has been developed after about 50 years of electromagnetic human experimentation, claimed to be involuntary. According to many scientists involved in this program, their names are not revealed for obvious reasons. Within a few years it is expected that DNA microchips, under the guise of medical breakthroughs that will be presented to launch the disease cure processes on speed and efficiency, will be implanted in the humanoid cerebrum, which would make it inherently controllable. RN.M will then have the ability to read and govern a person's emotional mental procedures along with the involuntary and visions. US-sponsored mind-control systems are also used to complement these illegal programs to silence whistleblowers and others that our government recognizes as a threat to their illegal strategies and those that are seeking the truth. Synthetic telepathy coupled with electromagnetic weapons used for pain have been the electronic weapons of choice by the perpetrators committing these heinous crimes against pro-SE plaintiff Stan J. Caterbone since at least 2005. Samuel P. Caterbone, Jr., the father of pro-SE plaintiff Stan J. Caterbone, U.S. Navy 1943–1947 was a victim of MK Ultra and experienced the same effects since at least the early 1960s. Brainwashing techniques via electroshock therapy, synthetic telepathy, vandalism to property, extortion of property and businesses were first used against him, a prototype for later use against pro-plaintiff Stan J. Caterbone. Ironically, the Lancaster City Police Department were the agents of choice in both occurrences. Pro-SE plaintiff Stan J. Caterbone J.'s brother, Samuel A. Caterbone, Sammy, U.S. Air Force 1969–1971, received the same victimization through the use of the LSD experiments of the same program while in the United States Air Force and after being discharged. Pro-SE plaintiff Stan J. Caterbone declared that after an explosive harassment campaign, connection with the synthetic telepathy occurred in 2004 to 2005. The synthetic telepathy first consisted of months of non-stop interrogations by male subjects who identified themselves as CIA operatives. The interrogations lasted hours upon hours at a time and covered just about every aspect of pro-SE plaintiff Stan J. Caterbone's life. The handlers, for lack of a better term, not only focused on the whistleblowing activities of ISK in 1987, but also covered mundane everyday experiences, as a form to harass and torture. In late spring of 2005, the handlers introduce females to the sessions. To this day, the torture consists of the same, interrogations mixed in with harassment, sex, and humor. It is the opinion of pro-SE plaintiff Stan J. Caterbone, that the only way to keep from desensitizing and numbing the harassment and pain is to experience pleasure and laughter so as to keep the magnitude of the pain at its highest level. This can be substantiated and validated by the fact that the Social Security Administration under Health and Human Services granted pro-SE plaintiff Stan J. Caterbone disability benefits in August of 2009 for symptoms and illnesses related to U.S.-sponsored mind control, and in fact stated in the award letter that disability was determined to begin in December of 2005, the date pro-SE plaintiff Stan J. Caterbone declared that the synthetic telepathy had gone full-time 24/7, without interruption, to this day. The nexus to Intentional Signal and Control, PLC, RISC, the CIA, the NSA, Lancaster, Pennsylvania, and U.S.-sponsored mind control comes through ISC Board of Director, Admiral Bobby Ray Inman. Bobby Ray Inman was the former director of the NSA, and the director of U.S. Naval Intelligence. Like today, when foreign police is politicized for partisan reasons, patriots and traitors are often confused as being one and the same. The operations by ISC and the respective intelligence agencies were conspired for tactical and logistical reasons that the Department of Defense and others could not find a way to communicate its objectives to Congress for approval without compromising its missions. ISC founder James Garin and others were indicted in 1991 and sentenced to prison terms in 1992. One must remember that the US-sponsored mind control programs were the direct result of the Soviet Union's accomplishments using microwave technologies to bombard the US Embassy in Moscow as early the 1950s and the use of German psychiatrists by Adolf Hitler in the 1940s developing psychological warfare programs. Both the German and Soviet mind control programs predate that of the United States. Thus, the beginning of the mind control arms race. Just this year, the Trump administration introduced the new military space agency, in an effort to formalize the weaponization of space and microwave weapons under one agency. This will convert the Department of Defense programs and that of the U.S. intelligence agencies to this new military space agency. Pro-SE plaintiff and J. Caterbone has penned amicus briefs in the following courts related to illegal surveillance programs and U.S.-sponsored mind control. United States Supreme Court, Case No. 18-5803, Caterbone v. Donald J. Trump, President of the United States, et al., a landmark habeas corpus case trying to set precedent that due to the illegal surveillance, torture, and control of a victim's mind, habeas corpus should no longer be limited to a prison being defined as a physical facility. United States Third Circuit Court of Appeals, Case No. 18-3326. Caterbone v. the National Security Agency, or NSA. United States 11th Circuit Court of Appeals, Atlanta, Georgia, Case No. 18-10134, amicus pending for Esteban Santiago, the FT Lauderdale shooter case. United States District Court for Western Washington, Seattle, Washington, Case No. CR 18-0086 JCC, amicus for Ton Kong Fan, alleged victim of U.S.-sponsored mind control who earlier this year mailed several packages containing explosives to military facilities in and around Washington, D.C. Who wrote letters complaining of common symptoms, including voices or synthetic telepathy and control of body parts, i.e. hands, arms, etc. Broward County Court, Broward County, Florida, Case No. 18001958 FIO, amicus recorded on May 2, 2018 for Nickolas Cruz re the Parkland High School Massacre. Nickolas Cruz was another alleged victim of U.S.-sponsored mind control, like Esteban Santiago had some training by the U.S. military in firearms and shooting, and also made specific claims of synthetic telepathy, or voices in the head. Both victims, like Stephen Paddock in the Las Vegas shooting massacre, had been suspiciously allowed to slip through the hands of several law enforcement agencies prior to the shootings. Supreme. The following is a sum of a transcript from the Cohens on harassment and covert surveillance of October 1 and October 2, 2016 in Germany. Dr. Nickolas describes the electronic weapons, their history, and their exploitation by the U.S. government. In order to discredit the use of electronic weapons on unsuspecting U.S. citizens, one must be able to legitimately discredit Dr. Nickolas in the following transcript. Dr. Nickolas is the eldest son of the late United States Congressman from Alaska, Nick Begich Sr., and political activist Peggy Begich. He is well known in Alaska for his own political activities. He was twice elected president of both the Alaska Federation of Teachers and the Anchorage Council of Education. He has been pursuing independent research in the sciences and politics for most of his adult life. Begich received Doctor of Medicine, Medicina Alternativa, honoris causa, for independent work in health and political science, from the Open International University for Complementary Medicines, Colombo, Sri Lanka, in November 1994. He co-authored with Gene Manning the book Angels Don't Play This Harp, Advances in Tesla Technology. Begich has also authored Earth Rising, The Revolution, Toward 1,000 Years of Peace and in his latest book Earth Rising to the Betrayal of Science, Society and the Soul, both with the late James Roderick. His latest work is Controlling the Human Mind, the Technologies of Political Control or Tools for Peak Performance. Begich has published articles in science, politics, and education and is a well-known lecturer, having presented throughout the United States and in 19 countries. He has been featured as a guest on thousands of radio broadcasts reporting on his research activities including new technologies, health, and earth science-related issues. He has also appeared on dozens of television documentaries and other programs throughout the world including BBC TV, CBC TV, Telemundo, and others. Begich has served as an expert witness and speaker before the European Parliament. He has spoken on various issues for groups representing citizen concerns, statesmen and elected officials, scientists and others. He is the publisher and co-owner of EarthPulse Press. He served as tribal administrator/village planner for the Chickaloon Village Council, a federally recognized American Indian tribe of the Athabascan Indian Nation for 5 years and served 4 years as the executive director of the Lay Institute of Technology Incorporated, a Texas nonprofit corporation. Currently Begich consults for tribal organizations, private corporations, and others in a number of research areas. Dr. Begich is credited with persuading the European Union to ban space-based weapons. Dr. Begich is a single person with 5 adult children, and 4 grandchildren. Dr. Nick Begich 2015 lecture transcript. And so I decided I would go in and look into this issue independently. And I did. I picked up maybe 30 articles and papers, design specifications, some things, and with friends encouraging me to publish, I published the first article that I had written on HARP back in 1994. So it's been a very long time ago, extremely low frequency signals or ELFs. These are signals that can be biologically active, can affect us as human beings and in very specific ways. And in particular, certain applications of the technology, and this gives you sort of a graphic illustration of the focus. These view graphs, actually, were given to me by the inventor, Bernard Eastland, prior to his passing. And we utilized them in our publications and in some of our work. So this gives you kind of a graphic showing the radio frequency from the array, moving up into the ionosphere and focusing that energy. His initial concept was to create a global shield, to be able to utilize the natural magnetic field lines that surround the Earth, be able to punch energy into this and then create this kind of global yielding effect. And the idea had any electronic device piercing that energy would be disrupted, like satellites, intercontinental ballistic missiles, virtually any electronic device that ran into this field of energy that was being amplified would be destroyed. Now, one of the other interesting parts of this and this kind of shows that, again, utilizing one of Eastland's graphics. So you can see like a field line and then you see this corkscrewing energy going around it. That energy naturally is occurring from the southern polar regions into the northern polar regions. And, in this case, they actually utilize the energy on the ground to couple with the natural energy, and then coming from the north to the south, create this corkscrewing effect, which accelerates the electrons and then creates this global shield. Now, that was his initial concept. And as a concept, it caught the attention of a number of people and eventually got funding from the Congress, initially at 30 million, and over the last few decades now over almost 300 million, which in dollars is not a lot of money, but when you consider, this is sort of the pinnacle of billions of dollars spent in ionosphere research over many decades. What caught my attention in terms of the technology of Eastland, I'm going to skip some of these that are not so relevant, was the idea that you could manipulate the ionosphere, and I'll use this as a better example. So one of the thoughts was that if you could punch or pulse energy into the ionosphere, so think about this energy going up and, like, a hammer ringing a bell. Every time it hits that ionosphere, the ionosphere itself vibrates and then it begins to send a signal in the ELF range. So you have a high frequency signal going up, punching the ionosphere which is energized then acts as a broadcast antenna in the sky, bringing back an ELF signal to the Earth, and in this case covering an entire hemisphere. Now, ELF signals, extremely low frequency signals, are very long wavelengths. They penetrate the Earth and sea. They're utilized for communication with submarines, as an example, the depth, because short wavelengths won't penetrate the Earth and sea. They're also used for what's called Earth-penetrating tomography, which in simple language or by analogy would be like X-raying the Earth or looking into the Earth for underground structures. But one of the side effects of ELF is the entrainment effect on the human mind. Because ELF signals will lock onto in what's called a frequency following response. And you can use a lot of different techniques to create a frequency following response. You can use flickering light, you can use binaural beat, which I'll explain in a few minutes. You can use electromagnetic fields such as this, or even the power grid itself can be modulated in such a way to create a signal that the human body will join with, will couple with, and begin to follow. It doesn't take a great deal of energy to accomplish this. This is the one that triggered my real interest in HARP, because this is the one that everybody kind of ignored and said, oh. In fact, the HARP planners said, well, if ELF has a biological effect, it's a side effect. It's an unintended consequence. We heard that phrase earlier today. But I don't believe that. I believe that it's an intended consequence. It's intended to grade populations in very specific ways. Now, this book was mentioned by my friend earlier today, Between Two Ages, by Zbigniew Brzezinski. Father of MSNBC host Mika Brzezinski of Morning Joe, Joe Scarborough, whom both got married this spring. And why this is an important book, it was written National Security Advisor to me. President Carter. This is around the time that Kissinger think tank, so to speak. Now, find this book. I really encourage you to find this book and read it, because it is not a prediction of what will come with technology. It's the blueprint, in fact. You can read this. When I first read it, he writes in a pretty convoluted style. It's a little difficult even in English to understand. But I really encourage you to read it because he predicted the economic changes that took place, the political changes that took place in the world over the last 40 years with a great deal of accuracy. And some will say it really wasn't the prediction. It was the plan. If you look within this text between pages and 56, you see a section that's dedicated to the kind of technologies we're talking about today, a mind control technology. And what Zbigniew referenced was a guy named J.F. Gordon MacDonald. And he was a geophysicist at UCL. He wrote a book, or, actually, a chapter in a book, and the chapter was called, How to Wreck Your Environment, which this is before Earth Day, okay, so he could get away with that. It was 1969 when that book was actually published. But what he said that caught Zbigniew Brzezinski's attention was, he said, if we could ever figure out how to electronically stroke the ionosphere in just the right way, we could return a signal to the Earth that would influence the behavior of people over huge geographic areas. Now, that's a pretty profound thing. But we didn't have a way to stroke the ionosphere in 1969. But we did by the 1990s. And that was, in fact, and is, in fact, the HARP system that can accomplish this. So the idea was, and it was kind of, in a gross sort of way, primitive, if you will, but what the intention was that if you could pulse the ionosphere, return this ELF signal to the Earth, you could agitate the population in very specific ways. You could make them passive, less aggressive, or the opposite by just amplifying that signal. And I'll explain a little bit of that as we go on. The other person that comes out in the last presentations, Jose Delgado, and this book he wrote, Physical Control of the Mind, Toward a Psycho-Civilized Society. And this is, again, a 1960s book. Those images that you saw in just this short video clip of Delgado's work, there is a good section in this text as well showing that. But in those days they used implants. They had to physically put something in the brain. And what Jose Delgado originally did, he was actually educated in electrophysiology at the University of Madrid. He graduated in 1950. Electrophysiology, as a degree field, thinking about it in 1950, now 65 years ago, most people don't even realize that's an area of higher education today, much less that far back. One of my mentors, Raul Nickolas, phonetic, he actually graduated University of Madrid in 1958, and his area of interest was, essentially, the same, biomagnetic and electric fields, effects on human physiology, and he spent his career studying that. Delgado, at Yale University, he initially was mapping the brain of primates and humans by stimulating various portions of the brain to figure out what was responsible for what kind of activity. And then he began to utilize the implants in those dramatic ways in those film clips with the charging bull, and he throws the switch and the bull stops, to demonstrate that you could take a creature from passive to highly aggressive to passive to highly aggressive, just like flipping on and off the lights in your living room. What Delgado discovered by the mid-80s is that you didn't need any implants. You just needed to manipulate the energy itself. And you didn't need a great deal of energy. Now, we've heard, I forget the amount of energy surrounding us now. Was it a quintillion? I believe it was 18 zeros after the one that we heard earlier. Back when I wrote the HARP book in '94, just radio frequency energy alone, it was 200 million times more around us every day than nature created in 1994. Now, when you think supreme about it, what did Delgado discover? He discovered that 50th of the amount of energy in the natural background noise of the Earth was sufficient to manipulate the behavior of human beings if you could hit the right frequencies, if you could hit those window frequencies that stimulated that kind of activity. Now, if you think about this again, by analogy, think about dialing through the radio stations on a radio. In between the stations you get the white noise, the static, you get no clear signal. But when you have resonance between the transmitter and the receiver, then you get a nice, clear signal. The same is true in our physiology.